Just let me know that I can be heard. Yeah. So today we are going to take the issues concerning women a little further. And what we are going to talk about today is sexual harassment of women at workplaces. There is a specific act which was made by the government of India in 2013. Let's go one by one through what all we are going to do in today's class. So first we are going to do the Vishakha guidelines, which came about in 1997. Then we are going to talk about sexual harassment of Women Prevention, Prohibition and Redressal Act 2013. Then I'm going to take you a little further after the details of the act, the Me Too movement, which started way back in 2006, but hit India in 2018. And from there, we will take you to the latest on the act of sexual harassment, which is G.S. Patel's Chief Justice from the Bombay High Court, who's given a hearing specifically for sexual harassment in September 21. And of course, along with it, we are going to talk a little bit about the she box. Now, coming to what is sexual harassment. So, sexual harassment at the workplace is any unwelcome, sexually defined behavior. It's any unwelcome, sexually defined behavior which has the purpose or effect of, which has the purpose or effect of unreasonably interfering with the individual's work, which in this case is a woman. I repeat, sexual harassment at the workplace is any unwelcome, sexually defined behavior which has the purpose or effect of unreasonably interfering with the individual's work performance or creating an intimidating, hostile, abusive, or offensive working environment. So it interferes with the individual's work performance or creates an intimidating, hostile, abusive, और offensive working environment. अब अगर आप ऐसे लिखेंगे विमेन पर और उनके प्रॉब्लम्स को हाईलाइट करने की बात होगी तो आप ये डेफिनेशन वहां लिख सकते हैं. अदरवाइज दिस इज ऑलमोस्ट 40 वर्ड्स. तो अगर आपका 150 का आंसर है या 250 का आंसर है तो आप ये डेफिनेशन नहीं लिखेंगे. तब आप कौन सी डेफिनेशन लिखेंगे? तब आप ये लिखेंगे दैट सेक्सुअल हैरेसमेंट इज एनी अनवेलकम. सिंपल सी 2 लाइन है. सेक्सुअल हैरेसमेंट इज एनी अनवेलकम, sexually determined, is any unwelcome, sexually determined, physical, verbal, or non-verbal conduct. It's a simple 2-line definition. Sexual harassment is any unwelcome, sexually determined, physical, verbal, or non-verbal conduct. Okay, having got the definition, I want to take you through all that happened before the Act of Prevention of Sexual Harassment, which is in short known as POSH. पूरा तो आपका जो लॉ है वो उसको डिफाइन करते हैं Sexual Harassment of Women, Prevention, Prohibition and Redressal Act 2013. पर शॉर्ट में हम कहते हैं Prevention of Sexual Harassment of POSH. तो POSH कैसे बना और उसके पहले क्या हुआ था उसके बारे में I just want to mention it briefly to you because that forms the basis of the 2013 Act. Now, before POSH came into existence, there was a case in 1997 of Bhavri Devi versus the state of Rajasthan. Bhavri Devi was a social worker from the Women's Development Program. She was employed by the Women's Development Program in Rajasthan in a place very near to Jaipur. तो मैंने डिस्ट्रिक्ट खोजने की कोशिश करी तो डिस्ट्रिक्ट कुछ आया नहीं क्योंकि जयपुर के वो इतने पास था. इतने पास होने के बावजूद भवरी देवी tried to intervene and stop a child marriage which was taking place in a very powerful Gujjar community. The community reacted with the head Ramakant and 5 other male who gang raped Bhavri Devi in front of her husband. There was no swab test available for the worker and she had to approach the court. First तो FIR lodge नहीं हुई, But after the lodging of the FIR, the court has given an order, dismissed the case, and Bhavri Devi had no other alternative but to approach the Supreme Court. Now, why are these guidelines called the Vishakha guidelines? Because Bhavri Devi alone could not have made it. Vishakha, an NGO, along with four other NGOs, approached the Supreme Court for redressal, and the Supreme Court, being the highest court of order, upheld and took cognition of the deep-rooted gender inequality that prevails in a patriarchal society like ours, and came up with a solution trying to understand that it was this deep-rooted gender inequality which was the cause of violence against women. तो सुप्रीम कोर्ट ने क्या अपहेल्ड किया? सुप्रीम कोर्ट ने अपहेल्ड किया कि it is the gender inequality of the society which projects itself as violence against women. We should not forget that India is a patriarchal society where men tend to dominate the women in almost all spheres of life. So Supreme Court held up that because of the prevalent gender inequality which exhibits itself, ya dikhti hai, in violence against women, there are certain things which the Supreme Court should do. Now, if we go a little back, in 1993, India has been a signatory to what is called as the Convention on the Elimination of. It's called CEDAW. 1993 में India has been a signatory to this convention, which is called the Convention on the Elimination of all forms of discrimination against women. India is signed and ratified the Convention on the Elimination of All Forms of Discrimination Against Women, which is the CEDAW 1993. Along with this, India is committed to SDG 5. SDG 5 क्या है? SDG 5, which is your Sustainable Development Goal 5, which clearly states that nations shall strive to formulate policies which bring about a gender equality in their country. That nations shall strive to make policies to bring about gender equality in the country. So CEW की signatory 1993 में India थी, and then SDG 5 also, where there's a commitment for gender equality. Of course, SDG 5 has come much later, but still, in that background, the Supreme Court decided to draw upon the CEDAW and come up with certain Vishakha guidelines which would make the workplace for women much more safer than as it existed before. The Vishakha case was heard by a three-bench jury consisting of Chief Justice Verma, Chief Justice Sujata Manohar, and Justice B.N. Kripal. Chief Justice Verma, Justice Sujata Manohar, and Justice B.N. Kripal. In the Bhavri Devi case, the Vishakha guidelines stated that sexual harassment leads to, अब ये points आप लिखिए एक एक करके. The court ruled that, I'll write sexual harassment as essay, it saves a lot of time. Sexual harassment leads to depravity. What is the meaning of depravity? A feeling of smallness, nothingness. खराब, एक बहुत गंदी feeling आती है. Sexual harassment leads to depravity among the victims. Among the victims. And was a gross violation and was a gross violation of their fundamental rights. मतलब औरतों की fundamental rights का gross violation है, especially कौन सी rights? As provided under article 14, 19 and 21. The court ruled in the Vishaka guidelines, first and foremost, is that sexual harassment leads to depravity amongst the victims and violates the fundamental rights of Article 14, 19, and 21. Then it came up with the second point, which says that policies should be formulated to make the working environment safe for women. It further went on to say that sexual harassment is any physical touch. ये विशाखा guidelines की definition है sexual harassment की. Don't get confused, it's more or less the same thing. A harassment of a sexual nature cannot change much, but whatever is given wherever can be treated like that. You can use whichever words come to your mind first. तो जब आप पढ़ते रहेंगे तो अपने आप आपकी एक definition बन जाएगी, which is good enough. उससे ज्यादा आप परेशान मत होइएगा. So according to the Vishaka guidelines, sexual harassment was defined by the court as any sexual behavior which is in the form of a physical touch or conduct, any unpleasant, taunt or misbehavior, showing of pornography, and asking for any kind of sexual favors, or asking for any kind of sexual favors. अब ये जो जितने characteristics है, जैसे physical misbehavior, taunt, unpleasant working environment, pornography, or asking for sexual favors will get repeated in various articles, whether it is the IPC 354A, whether it is the Vishaka guidelines, whether it is POSH 2013. So don't get confused about that, but these are the part of the guidelines. The fourth, the court said that that sexual harassment at workplace should be informed, और ये word use हुआ है, should be informed, produced and circulated. इसका क्या मतलब हुआ कि अगर किसी भी टाइप का SH हो रहा है तो SH की इंफॉर्मेशन सबके पास होनी चाहिए. It should be widely informed, circulated and produced. ऐसा नहीं है कि आप उसको अंडर कवर्स कर रहे हो और उसको छुपाने की कोशिश कर रहे हैं, ऐसा बिल्कुल मत करिए. Any sexual harassment which takes place at the workplace should be informed, produced and circulated. The court further said that every act of SH shall be dealt with and shall be dealt in an appropriate manner. Which shall include criminal proceedings, and disciplinary action. which shall include criminal proceedings and disciplinary action. The sixth point it stated was there should be a robust mechanism. There should be a robust mechanism. And this was lacking earlier, and that is why it became a landmark judgment. There should be a robust mechanism for time bound and effective redressal of complaints. There should be a robust mechanism for time bound and effective redressal of complaints at the workplace. It came up with the concept of a complaints committee. Headed by a woman. A complaints committee headed by a woman, including more than half its members as women should be put in place. In order to prevent, this is your 8th point, in order to prevent any pressure from higher ups and established a third party like an NGO. Should also be a part of the committee. It went on to say that concrete steps should be taken. To create awareness in the workplace. Or at the workplace, जो आपको ठीक लगे, at the workplace, as to what is sexual harassment, and how can it be addressed. Now, these 9 points became what is the Visakha guideline, and we trudged along with the Visakha guideline for 17 years doing nothing else about it. So the committees were formed, they had to deal with it in a time-bound manner, but reality में ऐसा कभी कुछ होता नहीं था. Committee तो बनती थी. I will talk about my organization also, and I'll share with you 2 episodes of sexual harassment which have taken place in the organization in front of me, where I was also a part of the chair. But that will be a little later. For now, it is sufficient कि 17 साल हम ये विशाखा गाइडलाइंस के ऊपर सेक्सुअल हैरेसमेंट को वर्क प्लेस पे कंट्रोल करते रहे. और फिर 2013 में सडनली we came up with what is called as the, so 17 years later, in 2013, we come up with what is called as the sexual harassment of women prevention, prohibition, and redressal Act 2013. अब ऐसा क्या हो गया 2013 में कि इसी के साथ साथ आईपीसी का जो सेक्शन था 354, उसमें ए जोड़ा गया, मतलब उसको अमेंड किया गया, वो भी 2013 में. तो ये आईपीसी का 354 जो है, ये जो क्रिमिनल प्रोसीजर एक्ट है, उसको भी उसी समय अमेंड किया गया। 2013 में कुछ नहीं हुआ, बट इन December 2012 there was what was called the Nirbhaya tragedy. And when Nirbhaya tragedy took place in India, suddenly all politicians and all our leaders got awakened to the issue that face women in workplace, in public spaces, और उस वजह से suddenly they decided to come up with what is called POSH. अब POSH क्या कहता है? POSH कहता है कि सेक्सुअल हैरेसमेंट वो है जो कि कुछ भी इम्प्लाई या एक्सप्लिसिट, so any behavior which tries to be implied or explicit promise of preferential treatment, promise of preferential treatment in her employment. तो एम्प्लॉई अगर एक्सप्लिसिटली या इम्प्लिसिटली उसको प्रेफरेंशियल ट्रीटमेंट उसके एम्प्लॉयमेंट में देना चाहता है फॉर सेक्सुअल प्रेफरेंसेस, then it is a case of sexual harassment. The act has enumerated 5 occasions which are to be considered as acts of SH. पहला, implied or explicit promise of preferential treatment in her employment. Then implied or explicit threat of detrimental treatment in her employment. तो एक जगह प्रेफरेंशियल ट्रीटमेंट हो गया, एक जगह डेट्रीमेंटल ट्रीटमेंट हो गया। फिर implied or explicit threat about her present or future, या अभी का जो वो काम कर रही है या जो फ्यूचर है उसके बारे में उसको, और फ्यूचर एम्प्लॉयमेंट स्टेटस, जो वो काम अभी कर रही है या वो जो बाद में करेगी, उसको लेके अगर उसको थ्रेटन किया गया फॉर नॉट कंप्लाइंग विद द एम्प्लॉयर्स आइडिया, then it will be considered as a case of sexual harassment. Then this is the third one. The fourth, interference in her work. Interference in her work, or creating and intimidating, or offensive or hostile work environment. Humiliating, this is the last one. Humiliating treatment likely to affect her health or safety. ये 5 circumstances हैं जिसके under 2013 a woman can approach for being a victim of sexual harassment. तो वो humiliating treatment आप उसको देते हैं, intimidating या hostile working environment उसको देते हैं, आप implicit और explicit उसको preferential treatment देना चाहते हैं, या implicit explicit उसको detrimental treatment देना चाहते हैं, या implicit explicit उसके future employment status को आप affect करते हैं if she does not comply with your concept of sexual favors, then it is a case of sexual harassment at the workplace. इसी के साथ साथ 2013 ये भी कहता है, पॉश ये भी कहता है कि अगर आप अग्रीव्ड हैं तो आप पुलिस पे जाके एफआईआर भी लॉन्च कर सकते हैं, और एफआईआर पुलिस को एक्सेप्ट करनी है, and this will be then covered under IPC 354A, or the person can approach a magistrate directly for redressal of a case of sexual harassment. तो कोर्ट भी जा सकता है विक्टिम, सीधा कोर्ट जा सकता है विक्टिम, और या तो फिर वो पुलिस स्टेशन में जाके एफआईआर भी लॉन्च करा सकता है. आगे ये कहते हैं that these cases will also imply for individuals from the same organization. कौन कौन किसके अगेंस्ट ये कंप्लेंट हो सकती है? People from the same organization, people, a third party can also be a source of sexual harassment, and the woman can approach any court of law for redressal regarding the same. अब कौन कौन सी स्थिति में ये सेक्शन 2O उनका 2N 2013 का सेक्शन 2N क्या कहता है, जो मैंने आपको पहले बताया है कि इंस्टेंसेस कौन से हैं जबकि आपको एसएच माना जाएगा. एसएच माना जाता है पहला फिजिकल कॉन्टैक्ट एंड सेक्सुअल एडवांसेस. A demand or request for favors, a demand or request for sexual favors, making sexually colored remarks, showing pornography, any other unwelcome physical, verbal or non-verbal conduct of a sexual nature. एक्ट 2013 पॉश ये कहता है कि ये सारे बिहेवियर्स जो हैं will be covered and treated as acts of sexual harassment. This is what this act says. अब इस एक्ट में जो एक बात बहुत अच्छे से निकल के आई वो थी अपॉइंटमेंट ऑफ अ कमिटी. इस कमिटी में इन्होंने ये कहा है दैट the Act of 2013 called for the appointment of committees. According to the Act, women are defined. In this Act, women, whether they are in the organized or the unorganized sector, whether they are working in an office or in a domestic setup, whatever be their age, will be covered by the Act. So the Act has a very wide definition for women. Point number 1. Point number 2, the Act calls upon the appointment of an internal complaints committee. It's called the ICC. The Act calls upon the appointment of an internal complaints committee wherever an organization is 10 or more. Wherever the organization has a workforce of 10 or more people. आपको ICC बनाना ही है जहां पर भी 10 से ज्यादा लोग हैं. अगर मान लीजिए कि आईसीसी अपॉइंट करने के लिए आपके पास वर्कफोर्स नहीं है, मतलब 10 से कम है, तो वहां पर एक लोकल कंप्लेंट्स कमिटी बन के रहती है. और ये लोकल कंप्लेंट्स कमिटी सारी जो विमेन है एम्प्लॉयड किसी भी कॉर्पोरेट ऑर्गेनाइजेशन में या प्राइवेट ऑर्गेनाइजेशन में, वो एलसीसी या लोकल कंप्लेंट्स कमिटी को अप्रोच करेंगे. द गाइडलाइंस फॉर इंटरनल कंप्लेंट्स कमिटी as well as for the local complaints committee is the same, that it should be headed, 1, by a woman. 2, it should have more than half is the word used, More than half of its members should be women. Third, it should have a third party intervention of an NGO. कभी कभी ऐसा भी हो जाता है कि जो इंटरनल कंप्लेंट्स कमेटी है उसके पास औरत जाती नहीं है, क्योंकि जो हेड ऑफ द ऑर्गेनाइजेशन होता है वो शायद सेक्सुअल अब्यूजर होता है. इस वजह से द वुमन डजंट फील कंफर्टेबल to complain against him in the same organization and approaches the local complaints committee. Now, in some instances, there is no provision for either the local complaints committee or the internal complaints committee. मतलब कई कई ऐसे तालुके हैं, ऐसे म्यूनिसिपल वार्ड्स हैं अर्बन एरियाज में जहां पर कि ये कमिटी एग्जिस्ट नहीं करती. तब वहां पे क्या होता है, जो डिस्ट्रिक्ट कलेक्टर होता है या डिस्ट्रिक्ट ऑफिसर होता है, जो कि आप कभी हो सकते हैं, वो ऐसे नोडल ऑफिसर को अपॉइंट करता है जो कि ये कंप्लेंट 7 दिन में सुनेंगे. They will listen to such a complaint in within 7 days and take it to the logical conclusion. What will be the logical conclusion? It will be reported to an intermediary or nearby sexual harassment committee, whichever is the closest, या जो उस jurisdiction को cover करेगा, उस जगह पे जाकर के इस कंप्लेंट को फॉरवर्ड कर दिया जाएगा. बट इस पे आपको इमीडिएट मतलब विद इन 7 days यू हैव टू टेक एन action. This is what all was enumerated in this act. So after this, after having done this, the act further goes on to say that there are specific time limits for the redressal of the complaint. There are specific time limits for the redressal of the complaint. For the redressal of the complaint. Penalties up to 50,000 or more, and this can multiply with as many number of delays or more, will be put for non-compliance of the provision, for non-compliance of the provisions. In their the ICC and the LCC, in their capacity of hearing a case of sexual harassment, are akin to a civil court, under CPC, or similar to a civil court under CPC. The report of the committee will be submitted to the disciplinary authority. And in cases where sexual harassment is proved, the report can also be forwarded to the police station for taking necessary action wherever the committee feels that this is what needs to be done. This has been a case of, so the Visakha guidelines and Visakha guidelines leading to the Act of 2013 was POSH 2013 was a case of judicial activism. पर ये activism भी 17 साल लिया, मतलब तो पता नहीं कैसा activism है. But Visakha guidelines were purely a case of judicial activism, because before that nobody had thought of doing it. So hats off to the Supreme Court for bringing it up and taking the women's movement a little further. अब आप आ जाइए वर्क फ्रॉम होम सिनेरियो में 2019 में. अब 2019 में ये जो वर्क प्लेस डिफाइन था, ये वर्क प्लेस तो वो है जहां पे आप काम करते हैं. अब अगर आप वर्क फ्रॉम होम कर रहे हैं तो क्या होगा? तो आप द कोर्ट हैज ट्राइड टू, नो दिस इज नॉट अंडर द पॉश एक्ट बट अंडर द IT एक्ट, the court has made provision that there is a concept of notional extension. There is a concept of notional extension. and that SH is to be treated as inclusive and non-exhaustive. और ये बहुत सारे केसेस है, मैंने बहुत सारे केसेस पढ़े, पर ये नहीं लगा कि आपको उनके बारे में कुछ बता के कोई फायदा होगा. बट दीज टू कॉन्सेप्ट्स आर वेरी इंपॉर्टेंट. दे सेड दैट it doesn't matter where the person is working from, so long as it is doing an act of work, the place doesn't matter. Therefore, there has to be a notional extension. Even in the case from work from home, it's very easy. When you are in the form of a virtual reality, you can disgrace the honor of a woman in any form. So he said that, so the court upheld that there is a concept of notional extension of the workplace, and that sexual harassment is to be treated as inclusive and non-exhaustive. मतलब हम इसको beyond the workplace की जो boundaries है उसके beyond भी ले जा सकते हैं. ऐसा interpretation 2019 में हुआ है, and you please include it as a part of your answer. Furthermore, जो लोग की ICC मतलब internal complaints committee के पास या local complaints committee के पास because of XYZ reason cannot go, now have the option of what is called the she box. The she box came into existence in 2017, or this is an initiative, an online portal for lodging complaints about SH, and it is an initiative of the Ministry of Women and Child Development, of Women and Child Development. इसमें the person can go to the portal. It's called the she complaint box. इसमें portal पे जाके lady can lodge a complaint, और फिर वहां पर से ये उसके respective jurisdiction वाले department को forward कर दिया जाता है. तो ultimately it goes to the concerned LCC or ICC only, but the method of it has now been streamlined and made easy. In fact, some of the states have come up with the concept of a pink box also. Pink box जो है ये ज्यादा करके जो ladies के schools है या colleges है उनके बाहर लगा दिया गया है, because the women were being made victims of eve teasing. तो उसको control करने के लिए it is a police monitored initiative in some states called the pink box, और इसके ऊपर कैमरा लगा दिया गया है और वहां पर जो है ladies का जो है monitoring होनी चाहिए. So wherever more women are coming together in a public place, there is a camera which is installed, the feed of which goes to the nearest police station. और जो pink boxes है वो conspicuous places पे लगाए गए हैं, औरतें वहां जाकर के या गर्ल्स वहां जाकर के अपनी कंप्लेंट डालती हैं और लोकल पुलिस स्टेशन इन्फॉर्म्ड रहता है और उस बॉक्स को खोल के वो कंप्लेंट्स के थ्रू जाते हैं ताकि दे कैन टेक द नेसेसरी एक्शन. These are the two steps which have taken place recently. Now we come to what is called the Me Too movement. Now Me Too movement started in 2006. It's hashtag Me Too movement, ना? Hashtag Me Too. ये क्या हो गया? In 2006. So in 2006, there was a sexual assault survivor and activist. उनका नाम क्या था? तराना बुर्की. उनका नाम था तराना बुर्की. And she talked about sexual harassment at workplaces, saying that she wants to break the silence of women and empower them so that they can come out from their closets or come out from their boxes regarding the sexual harassment, the shame that they have felt. So this initiative of Tarana Burki was to empower women who had been sexually harassed to come out on the public forum. और इसको करने के बाद से there were a lot of Bollywood stars. So पहले तो Hollywood में ये हुआ. So you had people like Ashley Judd, Govind Paltrow. You even had Tanushri Datta in India, all these people who came out in the forefront. The names are not important. What happened after what Tarana Burki did was there was a very big Me Too movement in the Hollywood industry, where they got their roles. The women claims that they got their roles only after having compromised to a great extent before they could get any kind of work. After that, of course, it followed to Bollywood in 2018. So 2018 में इंडिया में Me Too movement आ गया. Or Tanushree Datta was the first to come forward. Tanushree Datta was the first to come forward in the Me Too movement, and there are a whole lot of others who have talked about it. But for for me, it is sufficient to mention here that the Me Too movement, which started, got an external affairs minister resigning from the ministry. We are talking about MJ Akbar, who was the editor in chief of the Asian Age. As the editor in chief of the Asian Age, MJ Akbar has said to sexually harass about 14 to 15 journalists. और इस केस में when Ramana came to the forefront, there was her name is Priya Ramani. Priya Ramani. This is a case which I thought was worth mentioning. Priya Ramani came forward against Shri MJ Akbar, जो पहले जर्नलिस्ट और एडिटर कम चीफ हुआ करते थे एशियन एज के, और बाद में वो एक्सटर्नल अफेयर्स मिनिस्टर भी थे मिनिस्ट्री में, leading to his resignation. And this happened in 2018. And Priya talks about sexual harassment which has taken place with MJ Akbar way back in 1993. And she wrote an article in the Vogue talking about the SH which has taken place in Hollywood, and saying at the same time that she was abused by Akbar. Having said that on the public forum, in the manner of tweet, 14 other journalists joined. और एमजे अकबर ने क्या किया, उसने जाकर एक डेफेमेशन सूट फाइल किया. इस डेफेमेशन सूट के टाइम पर बहुत सारी जर्नलिस्ट ने अपने अपने तरीके से ट्वीट किया, which were taken as court of record, that they had been abused by Mr. Akbar. And when Akbar came up with what is called as his stellar reputation, वो कहता है कि मुझे defamation सूट क्यों फाइल करना है, क्योंकि जो मेरी stellar reputation है ये अफेक्ट हो रही है. एंड द कोर्ट हैज गिवन अ ब्यूटीफुल जजमेंट. जो मेट्रोपॉलिटन जज था, एडिशनल चीफ मेट्रोपॉलिटन मैजिस्ट्रेट, जिसने कि इस केस को हियर किया और अपना जजमेंट दिया, उसके व्हाट दैट पर्सन हैज सेड इज वेरी इंपॉर्टेंट. फर्स्ट, अ वुमन कैन नॉट बी पनिश्ड फॉर रेजिंग हर वॉइस अगेंस्ट सेक्सुअल अब्यूज. दिस इज द डेफेमेशन केस which that additional chief metropolitan magistrate, who was Shri Pandey, some Pandey, so you can write Shri Pandey or Justice Pandey, that should be good enough, that he has written that a woman cannot be punished for raising her voice against sexual abuse. He went on to say that sexual abuse takes away the dignity, and this is the most important thing, that sexual abuse takes away the dignity and self-confidence and right of reputation. Further, the metropolitan magistrate क्या कहता है कि जो sexual abuse है वो औरत की dignity को और उसकी self confidence को ले लेता है, और अगर जब वो ले लिया तो उसके against जो reputation की बात MJ अकबर कह रहा है वो कुछ भी उसके आगे stand नहीं करती. So the justice says that sexual abuse takes away the dignity and self confidence, and right of reputation can't be protected at the cost of right to dignity. I repeat, right of reputation can't be protected at the cost of right to dignity. The woman has the right to raise her voice even after decades. Akbar कहता है कि मुझे fix किया जा रहा है, and Priya Ramani has taken money for this, and the magistrate states that this is not true. A woman can raise her voice against sexual harassment even after decades of what has taken place, and says that her right to dignity is more important and needs to be held up vis-a-vis anyone's right to reputation. So Priya Ramani got about a sea change in the forum of sexual harassment in India because it helped to break the silence of several women who had become victims of SH. Now, Section 354A क्या कहता है? Section 354A deals with sexual harassment and punishment. So, a man committing any of the following, and I don't want to go into, I just read it for you. I won't write it here because it doesn't mean much. Physical contact and advances involving unwelcome, explicit, or sexual overtures, a demand or request for sexual favors, showing pornography against the will of a woman, making sexually colored remarks, shall be guilty of offense of sexual harassment. Section 354A कहता है कि अगर आप इनमें ये करते हैं harassment, और इसमें punishment होगी rigorous punishment up to 3 years or fine or both. मतलब आप you will be immediately taken under imprisonment, you will be taken under police custody, and a fine will be imposed, or both can take place. For the subclause 4, the section says that making sexually colored remarks and guilty of sexual harassment, this clause 4 will be treated with 1 year punishment and fine or both. And all these amendments which came forth in under Article 354 and made it 354A happened after the Nirbhaya episode, which took place in 2012 December. And all these amendments came forward in 2013, including POSH. So it was the government's way of telling us, or the legislature's way of telling us, that we do care about women. All these offenses under Section 354A are cognizable. Therefore, they become non-bailable. Person can be taken immediately under police custody. That was another thing which I wanted to share with you. अब आपको बताना है कि जस्टिस G.S. पटेल ने बॉम्बे हाई कोर्ट में सितंबर 2021 में क्या कहा. While hearing a petition for sexual harassment, Justice G.S. Patel came up with the following and led to a furor of the right of women to complain in courts. तो इसके अगेंस्ट एक पेटिशन फाइल की गई है सुप्रीम कोर्ट में, और ये क्योंकि ये 2021 सितंबर में हुआ, so everybody jumped and thought that this question will come this year. It has not come, and that is why I've taken it separately, because it will come for my students in 2022 in one form or the other. So अभी ये petition सुना नहीं गया सुप्रीम कोर्ट पे, इस पे कोई अभी जजमेंट नहीं आया, but it is important. So what does G.S. Patel says in his High Court order of 24th September 2021? He says neither name of party or any personally identifiable information will be let out to the public. So name of the party and उनकी जो personal identifiable information है वो anonymous रखी जाएगी. They will not come out in the public forum. Even orders and judgments will not be available for public display. The entire hearing of the case of sexual harassment will take place in the justice's chamber in the presence of the justice and the lawyers, who will be under oath not to let out any of the information regarding the proceedings of the case. Every judgment will be under a sealed cover. Only the minimum amount of people who are required to hear the case will be present. Even after judgment has taken place, the orders will be issued anonymously, मतलब without any reference to any party. ये information public में अगर जाएगी भी तो बिना किसी नाम के जाएगी, कौन इन्वॉल्व था वो भी किसी को नहीं बताया जाएगा. ये जीएस पटेल के कहने की बात है. अब इसके अगेंस्ट जो पेटिशन फाइल हुई सुप्रीम कोर्ट में, वो क्या कहती है? जो पेटिशन फाइल हुई वो कहती है कि ये हाई कोर्ट का ऑर्डर जो जीएस पटेल का है, इट टेक्स अवे द फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन गारंटीड अंडर आर्टिकल 19(1)(a). और ये ज्यादा इंपॉर्टेंट है बनस्पत वो जो कह रहे हैं, जीएस पटेल ने ये कह दिया कि पूरा सेक्सुअल हैरेसमेंट केस जो है एनोनिमस रहेगा. दैट्स द सम ऑफ इट. अब वो रिकॉर्डिंग करेंगे उसकी, उसको सील एनवेलोप में रखेंगे, वो 1 2 3 4 5 पॉइंट्स है, वो आप खाली ऐसे मेंटली नोट कर दीजिए. उसमें दैट इज नॉट इम्पोर्टेंट. व्हाट इज इम्पोर्टेंट इज what is getting affected. The petition in the Supreme Court says that by this High Court's order, the freedom of speech and Article 19(1)(a) of the Constitution is getting violated. So freedom of speech and expression is getting violated. The order also violates the principles of open court. It violates the principle of open court. It violates the principle of open court. It violates the principles of open court. The constitutional makers always had in mind that a well-informed citizenry, मतलब well-informed citizens, will govern themselves better, would govern themselves better, would govern themselves better. They also go on to say that the public discourse has an important role to play for delivering justice and for social empowerment of women. So they say that any public discourse helps to deliver social justice and women empowerment. मतलब जो डिस्कशन पब्लिक फोरम में होता है उससे women empower feel करती है and there is a sense of social justice there. Then it also says that this might cause a ripple effect. It might cause a ripple effect that may deter victims to approach the court. That may deter victims to approach the court. For a case of SH. मतलब इतनी एनोनिमिटी अगर आप बना देंगे तो औरतें अपने आप से कोर्ट जाएंगी ही नहीं, because they will be so hush hush and everything will be under the carpet. So if this kind of a mentality is there, then people will stop approaching the court in cases of sexual harassment. This is what the petition in the Supreme Court says against the order of Justice G.S. Patel. To conclude, I want to share with you my own experience of SH in the workplace. So as Government of India and being a senior officer, I have been a part of the committee, and yes, we are 4 members. We are 2 females, 1 male and 1 member from the NGO who can be a male or a female. The experience has been one which to the best of my ability, I can say is that every member tries to brush aside the harassment case as much as possible. There is also an umpteen amount of delay in getting all the members aboard on the committee. Attempts are made that the woman reconciles, and there is a provision in Article 2013 for reconciliation if the victim herself decides to forgive and forget. That provision is there. So members in the committee struggle to bring that about. I will just talk of a case which happened very recently, about a month back. I have a workforce of about 4,500 people, out of which about 2,200 are women. So half the workforce is women. And this lady was a chief reservation supervisor in Jalgaon. She was facing sexual harassment from the traffic accounts inspector, who goes through the details of the returns which are filed by the reservation office. So because of the treatment which was being given by the auditor, so you can treat him as an auditor, to this lady who was about 55 years old, a case of sexual harassment was registered in the internal committee, in the internal complaints committee by the lady. She did not get a reply from them except a preliminary reply that a hearing will take place immediately. That immediacy happened after 6 months. And this was, I'm talking of last year. And after that, she says that her experience with the committee was so bad because the accused and the victim were both called together. They were both made to sit in front of the committee together, which is something which is not done. But she came with her husband and she broke down in tears. And I had to go outside the proceedings of the internal committee. As a senior officer, I had to bring upon them that this should be settled as early as possible. And the person was sending her lewd messages, trying to intimidate her that he will go to vigilance against her and make a false case against her if she did not comply. And she was so scared. And after a month's struggle, I had to write a full paper and a report on whatever representation she had given to me, but justice was done. So, to get justice in cases of sexual harassment is very, very difficult. All this sounds very good, but the practical experience is not worth mentioning. In another case on another railway where I was working earlier, there was a CLA. He was a law assistant. A law assistant for the last 5 years had about 10 complaints against him in the internal complaints committee. And every time one member would defect or two members would defect, and the case never got resolved and he never got punished, and he had become so bold about it. We we couldn't do much because everybody, including the NGO, always sided with the CLA. The CLA had a godfather in one of the officers being a close relative, and he was the PS to the Minister for Social Justice. Yes, this is how it was, and this is a real story that I'm sharing with you. So every time this committee would come up for hearing, there would be a call from this PS who happened to be from a government department, and he would insist that the brother has made a mistake and therefore he should let go. Finally, when this happened with my staff repeatedly twice, I got a vigilance check done on him while he was traveling, and in another case for forged use of passes, I fixed responsibility on him and I removed him from service. He went in for appeal. His appeal was dismissed. And today the chairman railway board who's there happened to be my AGM, and he had heard that appeal and he also upheld the disciplinary authority, which in this case was me, and he upheld whatever orders that I had placed on file. And therefore, this guy has been removed from service and so far not been able to come back to the railways. But these are episodes where justice is being done when somebody takes it on personally to see that justice gets done to the women. Now, how a society grows is determined only by the way or manner in which it treats the most vulnerable section of the society, which is women and children. So if you want to assess the growth of this country, and we are at 123 in terms of gender inequality at a 189, I don't need to speak further. So when you talk about sexual harassment at the workplace, it is very, very real. And believe me, as women officers, as lady officers, the senior we grow in service, the more we are victimized and the more scared we are to say it out in public. It is very good if your spouse or partner or your relatives are in positions of power so that the senior gets a little scared. But sometimes men just do what they wish to do or what they want to do, and you really do not have much to control. So what is very important is a public forum and an environment where women can come out and speak about the problems that they have. If they can share and if they can tell their stories like happened in the Me Too movement, there is a case of real empowerment. Okay, we bring an end to this class. We have still some 3-4 issues to go through. So we'll talk about Panchayati Raj and its sections for women, and we'll talk about rape also, and we'll talk about entrepreneurship. I'll try and do that in a marathon class of about 2.5 hours or so, and hope to finish it for you. Thank you so much for your time. See you soon.